Now, tonight we're talking about what can and can't be said, about secrets, public and private, and about fresh ways we have of communicating and fresh demands there are for censorship and suppression. We're talking about war and terrorism and truth in the age of Twitter and WikiLeaks and enhanced interrogation. Now let me introduce the panel. To my left, until 15 years ago, Stella Rimington was Director General of MI5, Britain's domestic spy service, its ASIO. She was the first known, and I emphasise the word known, the first known woman to head any intelligence agency in the world. She was a warrior in the last stages of the Cold War and a controversial figure at times in the Thatcher government's campaigns against the trade unions. But since going legit, she has published her memoirs, she's judged the BAM Booker Prize, and written 7 spy novels starring Liz Carlisle, who, as it happens, works for MI5. The latest of these novels is Riptide. Now, Jeff Jarvis is a famous American blogger, writer, and he's a podcast star and columnist. He's devoted to the new. He is a fan of social media, and he is scornful of the doom and gloom preaching by privacy advocates. He sees the internet as an open public space, and he wants it to stay that way. But thankfully, he hasn't abandoned the wonderful, old-fashioned way of communicating by book. His latest is Public Parts, How Sharing in the Digital Age Improves the Way We Work and Live. Next to him, in the centre, Heather Brooke. Heather Brooke is a journalist and a self-confessed nosy Parker who went to Britain as a young woman with rather North American ideas of what citizens had a right to know. She wrote a great book about Britain's rather late-in-the-day Freedom of Information Act, and she showed how to use that legislation in her epic battles to help force the House of Commons to reveal MPs' expenses. Heather has since turned her attention to the world of hackers and whistleblowers and to WikiLeaks, and her latest book is The Revolution Will Be Digitised. Sitting next to her is Glenn Carl. Glenn spent 23 years in the spying game, analysing international terrorism and international organised crime for the CIA. In late 2002, he was sent to interrogate a man believed to be a great prize in the war against terrorism, apparently Osama bin Laden's banker. He tells what happens after that in his book, The Interrogator, a CIA agent's true story. And as far from me as he can sit is Michael Kirby, who was a judge from childhood. I forget now how it happened, but he went straight from 4th Street to the bench. And he ended up on the High Court, where he was a stimulating and provocative presence for 13 years. He is a fine advocate of sensible causes, and his Who's Who entry goes on forever, as we hope he will too. And recently he published his memoir, Michael Kirby, A Private Life. Welcome to you all. Shamelessly, because I'm so fascinated by the subject, we're going to start with phone hacking. I want to talk about phone hacking, and I want to see the ways in which we might explain where the boundaries of private and public are drawn in the age when you can essentially hack into anybody's phone who has been silly enough, like me, not to change the PIN number. I'm very interested in how this thing finally blew, because it didn't at first. A couple of journalists and a private detective hacked into the royal prince's telephone. They went to jail, no particular scandal. A few years went by, a few celebrities were hacked into, no particular scandal. And then, perhaps incorrectly, it was reported that the News of the World had hacked into the phone of a murdered schoolgirl, and an earthquake began, which is still continuing. Now, why, Stella? Why did it take that before the public sat up, took notice, and demanded that privacy be protected?
I think it took the Guardian newspaper, really, to actually draw attention to that particular angle on hacking. But quite frankly, I think that a large number of people had known that that sort of thing was going on for quite a long time. I mean, it was obviously very common in the newsroom of the News of the World, as we now know, and I guess it was quite common in other newsrooms as well. So it was one of those things that you get in British society anyway, where a lot of people kind of know things are going on, but it isn't convenient, really, for anybody to sort of make a fuss about it. But investigative journalism has been using all kinds of techniques, including hacking into people's phones, putting private investigators on to use kind of covert means to uncover aspects of people's private life. It's been going on forever. So I think it just took the Guardian, who thought, you know, maybe it was time to get at the tabloids, and particularly get at the Murdoch press, to begin to make an issue out of it.
But Heather, once the Guardian had done that, nevertheless there was a particular quality about this accusation that seemed to really kind of clarify the issue for people. That this was a young girl, she was missing, she was murdered in fact. This was not a celebrity, this was not a royal prince, this was a civilian. Do you think that's what it is that finally the community said, that's where the boundary's drawn?
Yeah, sure. I think that is why the public took notice. But I do have an issue about how much attention is being spent on this phone hacking case. There's 172 police officers investigating it right now. The fact is that journalists publish the material they get, and in this case, they obtained it illegally. That was a crime. It should have been investigated. It should have been prosecuted. It wasn't. And so for me, the real wrongdoing is with the police. Why didn't the police do their jobs? My bigger concern is that if we're talking about phone hacking, I mean, what News of the World did is small potatoes compared to what intelligence agencies are doing. I mean, they're hacking all of our phones, and they can do it all the time, in real time. And this is one of the things I write about in the book, is how increasingly our governments want to put interception backdoors into all of our communications, not just our phones, but our internet, our Skype traffic, everything. And yet we're not talking about this. So nobody seems to care. We're all talking about Rebecca Brooks. We know what they did, and they published the results of their surveillance. But MI5 doesn't publish the result of their surveillance. Who are they accountable to?
But doesn't that, Heather's comment, establish that you've really started at the wrong end, David? You've started
Not the
in
first
your
time
typical way.
Yes.
In your typical way, you've started with your obsessions about the journalistical profession, and you've concentrated on what journos do, because that's what you're obsessed about. But you've got to put it all in a context. You've got to put it in a wider context. And we have it on the assurance of the editor of the Australian newspaper that this is not a problem in Australia. And what are you clapping for?
Glenn, the point that Heather makes, we may get to the editor of the Australian a little later in another context, but Glenn, the point that Heather makes is a good one. I mean, what those journalists were doing in a bumbling and amateur way, though effective, is exactly what you people do, and you do it all the time, and that is not considered a violation, but why not?
Well, it isn't, and it isn't the same thing, really. The issue of civil liberties and the protection of the public from the invasive eye and hands of the government is a very live one in the United States, and I'm sure elsewhere too. And there are active debates about what sort of controls can be put or must be put on intelligence services and official entities in doing this. The difference however, is that the government does have a mandate to protect the public if it acts in accordance with law, and you can establish where the firewalls must be set to protect individual rights and yet to allow authorities to perform their mission too. But they are fundamentally different than a private entity that's just out to make money by exploiting people's scandals.
Jeff, why fundamentally different? Would you agree with that? That's a fundamentally different action?
I think we're conflating two things here. One is that I'm not sure that the hacking is about privacy. I think the hacking, as Heather says, was about illegality and decency and a certain matter of cultural evil in the company to do it. But I think Heather's also right here that when you hear these days governments are trying to fix the internet, though I don't think it's broken, about privacy as well as piracy and other issues as well. But government fancies itself the best protector of privacy, but in fact it is the worst threat to privacy, because government can use our information against us. It has the power of jail and law and taxation and so on. And I think that that's what we have to be aware of. For example, in the United States, we have rights involving our mail, our physical mail, that our communication has to be opened only with warrant. Those protections have been brought over to our communications online. And so we're not talking at the level of principles. We're treating things differently because of different technology, and that's what's wrong.
Indeed, because all of the battles were fought over the intercepting of telephone calls. And Stella, there's a whole history, isn't there, of what MI5 can tap. But yet, all of those fights seem to have seem to have been ignored in the new technologies.
Not quite sure what you're saying here. If MI5 needs to intercept people's communications, it has to make a case related to national security, and it has to get a warrant in order to do it. So that is our protection, and that process can also be scrutinized by an external scrutineer. And so all these protections are built in the law, as are the functions of MI5.
Who does it get a warrant from?
Who do they get a warrant? They have to have a warrant signed by the Home Secretary or the Foreign Secretary.
And is it specific to the person, or is it
specific to the person? You have to make a case that the particular person whose telephone, mail, whatever it is you wish to intercept, is a threat to the nation's security, and moreover, that you can't obtain the information that you need in order to develop the case by any other means. And there are, as I say, there's a whole raft of protections all built into the law. The issue now is that it is out of date, really, to assume that we only communicate by telephone and the mail.
Absolutely.
Most of us communicate by all sorts of other means, like Facebook and emails. And so the issue at present is extending those powers with all those protections to our use of the email, Facebook, or whatever it is. But that does not mean that MI5 or any other intelligence agency is going to scrutinize everybody's email. Can you imagine what size of organization, bigger than the KGB at its height, you would need to do that? And why the hell would you do it? The citizens at large are not presenting a threat to the security of the state. Certain people are. And the job of a security agency is to protect our civil liberties, to protect our freedoms in a democracy against those either who wish to overthrow our democracy and establish a totalitarian state, or kill us all for their own reasons. And that's what intelligence agencies, security agencies in democracies do, and they need the tools that are up to date in order to be able to do it with all the protections that are built in through the law.
Glenn.
Yeah, one should always be concerned about whether a government can encroach inadvertently or consciously on civil liberties and individual rights. There's a robust debate about that all the time in the United States, and I'm sure elsewhere too. But the facts are, even before the Patriot Act, before the events of 9/11, and since, that the federal authorities, the FBI in particular, and the CIA take their responsibility to obey the law, which is designed to protect individual rights, while allowing the authorities to do what Stella was just talking about, quite seriously. An example of how this is done: you must obtain, an FBI officer or a CIA officer must obtain a warrant to conduct a phone tap or tap into somebody's email account at all. Let's say the warrant is for me. and they are listening to my conversation. So long as I'm talking, literally, and I've seen this happen, I've participated in these operations, we will listen, and when someone else comes on the line for whom we do not have a warrant, we literally must turn the device off and wait 1 minute, and then we can turn it back on. Oh, still not the person for whom we have the authority, we have to turn it off. And those those procedures are subsequently verified by our superiors. So if we don't obey the spirit and the letter of the law, only to tap persons for whom we have warrants, we will be punished and prosecuted.
Glenn, we watched The Wire.
I never have.
You watched The Wire.
The warrantless wiretapping that the NSA did that was exposed by the New York Times, wasn't that different, though, in the sense that it wanted to get a pattern of communication to then see the anomalies in that communication, so that's why they were listening to us all, to get that pattern of communication, not necessarily to listen to an individual who was targeted, but to see how we all operated and then find out what was unusual in that pattern.
What do you think about that, Jeff? Fair enough, or outrageous, or?
That's what we're negotiating right now. I mean, I'm an odd beast at this because I'm also was at the World Trade Center on 9/11, and I saw the exact impact of what happened there, most personally. And so there is a need for security in a society. The issue here is whether we can trust the government to act properly and with restraint and with controls and with checks on that or not. So I think there is a need to seek security, but there's a greater need for these controls and checks.
And I think there's a real issue about one area of government going to another area of government, as Stella says, apparently is the case in the United Kingdom.
Exactly.
Because normally the way we put checks is to require that the enthusiastic executive branch goes to somebody who is either a judge or an ex-judge, who will, as it were, look dispassionately at the matter, and that's what we do with telephonic interception. And the question is whether or not we have to extend that logic into the new media and to have somebody who's outside the enthusiasts. The problem of enthusiasts is that they get carried away. Is rendition, for example, in the United States, rendition of people, say, to Egypt, where they can be tortured to get information, is that specifically covered by US law, Glenn, or not?
Oh, it is, yes. The CIA is...
Must be allowed, then.
Well, it's not allowed, and there are some... we have the assurances from the editor of the Australian...
This is the problem. I'm glad to hear that Americans also accept these assurances.
Glenn, please, I mean, you're amongst friends here. And we allowed the Americans to render to the Egyptians an Australian citizen. And then we provided the Egyptians with material to help them interrogate him. And then at the same time, we lied to his wife about where he was and lied to the public about where he was. So please, you are amongst friends. We're all cooperating. We're doing our bit here.
I always trust everybody. Well, there's the law, there's the spirit, the letter, and the facts. The law... That's a true statement, actually. No, the law is clear that American officials, CIA, State Department, FBI, or so on, we may not, the United States may not hand an individual to a government that we believe will violate human rights, such as in torturing someone. So what happened in the 90s and then subsequent to 9/11? If we wanted to give someone to the Egyptians, and Michael Scheuer, a predecessor and colleague of mine who was head of the Osama bin Laden branch in the 90s, has spoken about this. The authorities would write an affidavit saying, we have assurances from the Egyptians that they will abide by their international obligations.
And they knew that that was not an assurance that they should accept.
Well, I think the fact is, yes, that's correct.
Well,
but that was the maneuver done to hand someone to the Egyptians or the Syrians.
This is the problem with enthusiasts. They get carried away and they need scrutiny, and scrutiny by very practical, hard-nosed people who are experienced in the misuse of power. That's why Justice Hope did the big investigations here and laid down a very good regime in Australia, but the question is whether it's kept up to date. I'm not at all sure.
Well, that's why in the United Kingdom we also have these layers of scrutiny. You start off with a government minister, then you have a scrutineer who is a judge, and then you have a parliamentary oversight committee, and so we go on with these layers of scrutiny in order to avoid exactly what you say, people convincing one other person that what they're saying is correct.
I wouldn't say those layers are at all effective.
Well, how do you know that?
Because
Excuse
the
me,
main,
as you make your comments.
Yeah, the main scrutineer of eavesdropping, for example, is the regulator, is the Commissioner of Interception, and his report is totally anodyne. I mean, there are no real figures.
Well, that's not actually true. You haven't got your facts right there, but we won't go into the details of the precise
please. I would be interested to hear
mechanisms.
This sounds like a job for a judge.
He's desperate for work, this man, desperate for work.
There is a point, though, that we don't have any idea in Britain the volume of interception that goes on.
Nor do we here.
And people who have been incorrectly intercepted have no redress. They're never informed about it. Information is gathered on people, and who is scrutinizing it? It is other parts of the government. It's not the legal system. And that's where we're now starting to move in Britain also into secret trials. So not even the defendant, when he goes into a
Hang
into
on,
a
we
trial.
have not moved into secret trials. There is a green paper, which is a paper for discussion about
Yes.
whether in certain limited circumstances
But I think this
it
is the
might
tragedy of
you
the,
just
of,
got
of
to
our
be a bit
democracy.
accurate.
That we are giving up in the name of fighting against terrorism. We're giving up the things that make democracies great.
Can we
And
get to
that
secret
is-
trials in 1 second?
Yes.
Because I want to ask another question about inception. Because in this country, as I understand it in the United Kingdom, it does seem to me there's a history of ceaseless pushing for fresh powers by domestic and foreign security services. And in this country at the moment, there is a push for the power to compel ISP providers to retain for up to 2 years information about traffic. It's not the contents of the traffic, but it's information, again, about the patterns of traffic. And it's controversial in this country, but it's not much discussed in this country, it has to be said. The same thing is happening in Britain at the moment. Has it been, has MI5, has MI5 been granted the power?
No, it's a proposal at the moment. It was in the Queen's speech. Well, it's the point I made at the beginning. I mean, we now communicate in different ways than by the telephone and writing letters. And if you're going to have your protective security adequate, you've got to be able to intercept the means by which terrorists or spies or whatever it is are communicating.
But at the same time, if you're going to have adequate protections of your rights, you have to carry those protections on a basis of principle across any medium and any technology. So the rights that we have with a physical letter should carry over to our Gmail, but they don't now, I think, in any of our nations.
And this is a problem for the Americans, because one of the reasons for their revolution was that George III insisted on the general warrant. That is to say that you could just give the powers to the executive government to go and have a good sniff around and do what they wanted, whereas they insisted, and it came into their constitution, that there had to be a specificity. And your problem now is that you don't have that specificity. Now, we don't have the same constitutional requirement of it, but we've, as it were, edged our way to it by the Hope Royal Commission into the security forces, but it hasn't kept up with the technology. And this is the problem, I think, is common to Western countries, and that's where we've got to go. I think we've got to reopen the Royal Commission.
But instead of keeping up with
a very good judge to do it.
But Your Honor, instead of keeping up with the technology, shouldn't it stay separate from the technology and say that this is a principle of law that says the private communication is private unless these circumstances exist? By trying to keep up with the technology, you're necessarily always behind it, and thus there's always a loophole to go and get around.
I thought you were an anti-privacy person, and suddenly you're emerging as
I'm both,
a great privacy defender.
No.
I thought you were real
Michael, subtleties. Even in Americans, it can happen.
There's not much subtlety about the First Amendment in the United States.
Amen, Your Honor.
It is the strongest guarantee of freedom of expression.
I recommend it highly.
And they don't get it that there are other values in society that have to be balanced with free expression, including privacy and honour and reputation.
Well, I'm sure we agree, however, that there is a nuance that we haven't touched upon. We've danced around a little bit, though, and that's the clash between the need for security agencies or organs to conduct their jobs so as to keep us safe, as we heard, and the need to protect the First Amendment rights, in the American context anyway.
We don't have them in this country.
Yeah,
We've decided it's a bad idea.
Yes, but the High Court has found that there are limits on the power of Parliament to take away from such level of free expression that is essential to the working of the democratic nature of the nation.
Absolutely.
So that's how we get into it. It's a limit on legislative power that inhibits the freedom.
The dilemma that I'm working towards, though, is how does one have oversight and control of the executive agencies without hindering their work in a way that is detrimental to the national security? And the solution, which is always imperfect, but what I think the best you can do is you can't have total transparency and let the public decide what makes sense. You have committees that are basically, you hope to separate them from the executive, so you don't have judge, jury, and hangman all in one entity. And you'll have, in the United States, you'll have special FISA courts, where you'll have oversight committees who have the mandate and the clearance to look at these issues in a way that protects, one hopes, the freedom of speech and privacy rights while allowing the authorities to conduct their job too. It's a never-ending dynamic.
The more
but
secret
that's
that
the
is, the
middle
less trust
solution.
we are going to have in it, which is your
But
point.
as well as that, there is a problem in asking a judge in his chambers or an ex-judge. He's presented by a very urgent application. It has to be done at once, and you've got these ashen-faced officials saying, this is something
the fate of the nation.
And you don't get, you can't see all the information, you don't know all the difficulties, and you've got to make the decision at once. It's not much of a check, but it's at least a check, and the fact that you've got to go and ask it is an inhibition on plainly unacceptable interferences.
Yes, that's the thing.
Disproportionate interferences in
privacy. It's the fact that you have to ask that is the most effective check, because the statistics of it's not quite a rubber stamp, but the FISA court grants something like 99.3% of all requests, something like that,
and
for the reasons that you stated.
Yeah, but
and the police have always found the friendly magistrate who'll give them any warrant they ever want. I mean, I don't want to be entirely sceptical about this, but
I don't think that's how it works. I think there's a roster and it just goes in cycle.
But let's get But let's get to the issue. Let's get to the issue of secret courts.
You've got off journalists now. You've completely forgotten what you started with. You whet our appetite about journalists, and then you take
Are you inviting me to go back
security.
onto the ground on which I am most secure? It's not usually your technique. Heather, the secret courts. And my question to everybody on your panel, how is the public to have faith in the findings of courts to which the public has no access, to which the accused is given no right to know the case against them? I understand in Britain there is to be a committee of lawyers who are vetted to a certain level, who are allowed to defend people, and they can know things that their own clients aren't allowed to know.
I don't think we know what the situation in Britain is going to be, because we have only, as I say, there is a proposal in the Queen's speech, and there is a green paper proposing that in certain very limited circumstances it might be advisable to have a certain kind of court where secret information can be made available to both sides, so that the court, but without the defendant, can take a decision and advise a decision given the secret information that's available. But this is only a proposal, and I think it's got to go through a lot of debate and discussion, and certainly the civil liberties side will object to it, and it may well never come to pass. But it's an effort to avoid the kind of situation that arose with some of the Guantanamo Bay detainees who said that they had been tortured, which obviously was true, but also said that present at the torture, etc., were members of the British intelligence services. Apparently there was information that might have been made available if that hearing had ever actually taken place, but the government was not prepared to make the secret information available, so they paid these people large sums of money, millions of pounds. as compensation because the cases couldn't be heard. So it's in an effort, as I understand it, and I'm an outsider here, it's in an effort to avoid that situation arising again that this proposal has come forward.
Oh, well, that sounds like a grand idea, but of course, the British are so far ahead of us here, we left our people in Guantanamo. You got yours out, which was very sweet of you. But apparently ours had to stay in for reasons which weren't entirely clear. To shift ground slightly, but only to sort of go to a higher level with the whole thing, for all the highfalutin talk, panel, isn't the principal reason for state secrecy to cover mistakes?
Heather. Well, I'm going to wade in. I feel that national security is becoming the new word of God, that it can't be questioned, that you can go to a certain level of questioning authority, and then you come to this brick wall, which is national security. And if we're thinking about what is national security, who are we protecting? Are we protecting the political status quo? Are we protecting a bureaucratic fiefdom? Or are we protecting the general public? And I think it must be the general public. And in a democratic society, if the security services are to protect the general public, then they must in some way be answerable to the people. And that's not to say they can't keep certain things secret, but there has to be some form of oversight. And at present, I do sense that they are they're disrupted, as all politicians are, by the internet, by the way it's diffused out power. And the idea of free citizens communicating freely without the government knowing what they're up to scares them, frightens them. They're no longer the information gatekeepers, or the power gatekeepers. And they want to maintain that status quo. And I feel that that's why we're seeing this massive power drive from intelligence agencies across the world about trying to figure out a new way to re-engineer the internet so they maintain control.
Jeff.
Government has become secret by default and open by force, whether that force is Assange or a reporter or freedom of information. Government clearly must become the opposite, which is to say transparent by default and secret by necessity. And there are necessary secrets related first and foremost to citizens' privacy, related also to security, related to some matters of diplomacy. But the problem, and I think the WikiLeaks revelations revealed this, that the banality of secrecy, the overdoing of secrecy, government robbed itself of the credibility of being able to decide what should be secret when too much is secret. And that's the position we're in now. So we can keep trying to force the secrets out of government. And of course, part of the problem with WikiLeaks is that what you would hope it would lead to is more openness, and of course it leads at first, the reaction is to the opposite. It's more walls, more steel, more iron put around us. But in the long run, the internet will demand and cause openness. The lesson of WikiLeaks is that it's much harder to keep secrets, and if you're going to keep secrets that shouldn't be secret, you're going to lose your authority to do so.
I think the lesson of WikiLeaks was that the Americans didn't really know what secrecy was, because they had this huge database, which they were calling a secret database, which contained all kinds of stuff that clearly wasn't secret, and also was available to, as I understand it, thousands of people. You can't have a secure database or a secret database if you're going to make it available to all kinds of people, including a young man who'd only just joined the army or whatever, whoever he was. A troubled youth who was going to put it all on a disk and take it home. So I think that's the lesson of WikiLeaks.
But the interesting thing is that really it's now quite a time since the WikiLeaks were revealed. And save for one or two instances, I saw a report in a News Limited paper last week saying that somebody in Iran may have been executed because of the WikiLeaks. That when you look at it, there hasn't really been a fallout. Okay, there's been some embarrassment and some private matter has been revealed, but it's really no big deal, isn't it?
Well, but it helped cause the Tunisian revolution, which I think is a positive.
You think is a positive?
I think that's a positive. Yeah.
I think that gives dramatically too much credit to WikiLeaks to doing anything in the Arab world.
We're not talking about the motives, we're talking about the consequences.
Of the information.
I wouldn't attribute the revolution, the Arab Spring, to anything to do with WikiLeaks whatsoever, but I don't want to talk about that point for a second. You asked, we touched on so many things in the last 90 seconds, about 12 different topics, 13 different ways.
We got hours. Don't worry about that.
You know, I'll try to bring some coherence.
He'll bring it back.
Maybe I can bring some direction or coherency
He'll bring
to
it
our
back to a
comments.
job for an old judge. Glenn, I'm sorry.
Not
keep
so
going.
much of the old.
Yeah, your initial question was, what is the point of classification or secrecy? And does it serve to protect
Overwhelmingly
secrets
to protect.
or to avoid embarrassment?
Yeah.
And of course, in fact, it should be the former, and it is both. To classify something so as to avoid embarrassment for the government is not necessarily an illegitimate reason to classify something. There are a large number of facts and issues and thoughts that legitimately should be kept secret for the functioning of government.
It's not as much as they claim, though.
I agree entirely, and that's almost my next sentence. It's also true, and I think probably maybe all but two of us on the panel, because you're the pure citizens.
It's a small majority you have there.
But we have the power.
Do you have to be so blunt?
There's transparency.
Clearly, a lot of things, we all have observed this in the government, will be classified by default, unthinkingly, because that's simply how stuff is done, and also more consciously, because it would be in some way embarrassing. And it's an endless struggle to try to act rationally and not to do CYA classification. I don't think there, frankly, is a clean solution to this. This is something, it's like...
Well, getting caught a lot.
It's like vacuuming the apartment. You have to do it all the time. And that's just how it is. So that's what secrecy does for both things. But I think that the concerns that we are losing our way, I've lost what you said, although it was very pithy.
That's rarely said to me. Thank you very much. I think that you lose the authority to set secrecy when the secrets are revealed to be banal and, in fact, sometimes helpful. And so that's the issue: is that
over-classification of documents is a real problem.
Yes.
But I don't think that there is a clean solution to that. You have to continually
But
try
I think two of us might argue on the panel.
Now, if I could say something
the
about
internet may be a help to that, because the internet does force openness in ways that institutions cannot grapple with right now.
I am agnostic on
It's
that. I
a
don't know.
question. Isn't it a question of whether the First Amendment in the United States is going to permit regulation of the internet in a way that damages the freedom which you protect for the rest of the world by what to us seems a somewhat extreme and absolute position of protection of free expression under
I
your
recommend
Constitution?
free expression highly and the protection of it highly. We have Section 230 in the U.S. that, for example, protects a system provider from liability for the speech of others on their system, so that we can have that speech, which I think is a wonderful thing. It's kind of the online equivalent of the First Amendment.
Statute. That can be undone.
I realize that, but it also goes to the principle that speech is important. And yes, that's exactly what I hope for. Is the First Amendment will
That's
prevent
going to be a very
efforts.
important battle, because though I personally do not support the extreme position of the First Amendment, I secretly hope that in this case it is going to stand to defend the free expression on the internet for all of its faults and dangers. I think that is a very, very beneficial thing for freedom in our world.
But it's not just about things like this. It's also, if you look at the EU, Viviane Reding's proposed regulations on privacy in the EU, for example, argues for a right to be forgotten, which sounds quite nice. But if you and I have an interaction, then who owns that information? What's to be forgotten? If you say something should be forgotten, then that impinges upon my right to free speech. They've talked about she talks about a privacy by default, which would affect, if that were the law of the land, we'd never have Twitter, we'd never have Flickr. And these are things that aren't just
some way we can get rid of emails.
Amen to that. So these are things that aren't just out of the First Amendment; they're also out of principles of law in other nations as well.
Glenn,
I want to go back.
change gear.
Yeah, I want to go back to the WikiLeaks for a second and say something that will apparently be contrarian for many. I've heard this quite a bit. It's almost become conventional wisdom. It's sort of a little bit of intellectual totalitarianism that one take as given that the WikiLeaks phenomenon was a positive event. And I find it appalling, frankly. And I'm glad that the man who leaked the stuff is going to jail. And if I could put Julian Assange in jail, I would do that too. No citizen gets to choose what the government can do with respect to the regulations and the procedures that we elaborate carefully and laboriously through the process of government on what should be classified and what shouldn't. No one can be a vigilante for justice, and no one can be a vigilante.
Are there no whistleblowers?
Are there to be no whistleblowers anymore? No leakers? No. I mean,
that's the basis of journalism.
That's how we move. That's how we discovered so much about the world.
I'm in favor of a free press, and leakers have a.
What would you think about? What do you think about the Pentagon Papers? Should they have been leaked?
There's a difference in degree. Yes, there is a difference. Yes, there is. There is a difference in degree and quality. And I was talking about this the other day.
They were actually more highly classified. Yes. They were more highly classified documents than what was leaked in WikiLeaks. So
we're talking about what the issue is, and the Pentagon Papers were talking about a war with ultimately 60,000 Americans dead and 1 million Vietnamese dead because of actions that had been misrepresented by authorities. That is not the same thing as someone who says, I just think that everyone should know what's going on, and that the government, by definition, any decision it takes with regard to classification is wrong, and so I will unilaterally share all these secrets.
That's
not the same thing.
You pretend you're mouthing to a Lady Gaga tune, you download it onto a disk, you take it out, and the world discovers an enormous amount about itself.
About its own government, about the government of the people. It is our government, it's our information.
And what we discovered about our government, because there was all the material there about what our officials were doing. But I wonder whether the problem with WikiLeaks, in the end the problem with WikiLeaks, is that there's so much of it, Heather. You worked on the WikiLeaks stuff. How do we as the public deal with this enormous quantity of material? We're defeated by it.
This was Stella's point earlier.
Well, I'm not a great fan of Julian Assange myself, having worked with him on the diplomatic cables, and I don't think that you should let that get in the way of what WikiLeaks as a concept is, and I think it must be supported as a concept, this idea of whistleblowers. By all means, charge the man if you think he committed a criminal offence. Well, then bring a charge. But if you don't...
Has been charged.
In the open.
Julian Assange, I'm
talking
about...
I don't think you can charge him because he's not American. I don't know if you could do that or not.
So if what he's done and you think what he's done is illegal, then yeah, bring a charge. But if not, and I don't think it was illegal in that sense, I thought it was very disturbing the way parts of the American government reacted when the diplomatic cables were published. So I worked on the cables at The Guardian, and yeah, they were very disturbing for people in power, because you're starting to publish things that have never been published before. You're really getting into the heart of power when you're publishing diplomatic cables and information about war. But I think that's part of what is so revolutionary about our time, is that we are starting to get right in there with power as people. We're not accepting these little walled gardens where people in security services, people in the cabinet office, they can make decisions that affect all of us, that spend all of our money in taxes, and we're just going to trust we're going to trust you all. Yeah, there can be some level of trust, but I think there has to be. I certainly, as a citizen, I want to know more about what's happening. I demand more. I can find out about all sorts of things on the internet. Why can I not find out about my own government?
I think for the same reasons that lawyers and clients have a privileged relationship, so can government officials in the conduct of their business have legitimate reason to maintain confidentiality.
Yes,
but that's not quite right. The privilege belongs to the client, not to the lawyer, and it is strictly controlled and has to be very relevant to the subject matter, whereas the whole point of WikiLeaks is that it's demonstrated that an awful lot of it is just gossip, mass material, stuff that should never have been classified. And the bottom line is, how many real cases of actual damage to the vital interests of any government have been demonstrated by it, as distinct from letting people know the general nature of their
I wanted to say one other point. Please. At the same time that people in government say, isn't it terrible that we need to have this level of confidentiality, they're on a wholesale campaign to just strip all citizens of privacy. And that's what we're talking about, the interception capabilities. We're talking about the way we're all under surveillance with cameras. And we're all made to be incredibly transparent to authority. And yet authority then demands to have that confidentiality.
between us, does Britain really need all those CCTV cameras? I mean, just between us.
The CCTV cameras, as I understand it, have been put up by all sorts of authorities, certainly not by the security service. They have been put up by shopping centres. They've been put up by people who monitor the speed people are driving at. They've been put up by the people who run our stations to make sure people don't get on trains without tickets. So the trouble was that there was no regulation to prevent the world and his wife sticking up a CCTV camera for their own purposes. And that's how this great proliferation of cameras got there in the first place. And then all of a sudden, of course, we had dreadful events like the bombing of the London Underground, 7/7 as we call it.
And they turned out to be quite useful.
They turned out to be extremely useful. And on one of the cameras that had been put up by the railway company or the underground company, there were pictures of the people going off to do the bombing with the bombs on their back. So they then turned out to be useful. But you know, that was a kind of happenstance in a way. It wasn't the security authorities who decided that everybody must be surveilled every minute, you know, when they left their house. So that's how it happens in democracies. If you don't have regulations, people go and shove up cameras, and then some disaster happens, and they turn out to be quite useful. But it doesn't mean that the security authorities are watching now every single camera that exists all over the United Kingdom, just in the hope that they might see somebody with a bomb on their back. They've got far more things to do and have to be far more focused.
Now I'm going to change gear again because time is marching on. 3 members of this panel have recently written their memoir. Well, not recently, but have over time written their memoirs. Glenn, of course, is here with his interrogated memoir. Michael Kirby at the far end, who happens to have a copy on his person. And Stella, who some years ago now wrote her memoirs as well. Michael, were you free in your memoir, if you had wished, to write about the workings of the court on which you sat in order to explain to the Australian people what really goes on behind the doors of that court when law is made?
Well, there was no law to stop it, but there are conventions and politeness and courtesy and decency in dealings, and this is mainly a personal memoir. It's not really a memoir of my court work and my court years.
No, I understand
there
that.
are restraints on what one should say. I mean, do you have no restraints? You have restraints that you observe. You don't reveal your sources. You don't reveal things that are told to you in confidence, or you wouldn't reveal things that
under
are
WikiLeaks
embarrassing.
we should.
And you play by the rule that unless a person reveals their sexuality or in some way acts in a hypocritical way, you play by the rule that it's not revealed. That is the rule in Australia.
But I'm talking about a different situation. The United States of America now, for something like 20 years, there have been lots of books which talk in detail about the inner workings of the Supreme Court. And there's been nothing like that ever published in this country, and I think nothing in the United Kingdom which actually has ever examined how the old House of Lords or the Supreme Court in the United Kingdom actually works.
You obviously haven't been reading my website with all of its thousands of... I mean,
and the messianic photographs you have.
I have revealed the way in the High Court of Australia. We have meetings, we have discussions, we go through and A.J. Brown's wonderful biography of me. Well, I don't agree with all of it, but it does reveal some of the ways the court operates.
But in contrast, Stella and Glenn have both written books about their professional lives, their memoirs of what they did at work. Did it come as a shock to you to be vetted, to have your book vetted, and to be told what you couldn't publish?
Not at all. I knew what the rules were, and my book is not about the inner workings of every operation or whatever. You're thinking about Peter Wright, if I may say so, who's a different thing altogether. I wrote my book very carefully, and it is a book about my life primarily, not about the workings, as I said.
And we are professionals.
And I knew what the rules were. The rules were that anything I wrote that related to my work in the service, I had to submit for clearance, which I did. And,
How did you go?
There was a silence in Whitehall when I submitted my book for clearance. They didn't know what to do. This kind of corporate gasp went round. And I heard nothing for about 2 months, and I wondered what on earth was going on, because I'd written this book very carefully. I knew what I should and shouldn't say. And then somebody within the clearance process put the uncleared manuscript in a brown paper envelope and sent it to the Sun newspaper, which is our most tabloid of tabloids. And they didn't know what to do with it, so they put it in another brown paper envelope and sent it back
They didn't publish it?
No, well, they couldn't, because it was my copyright. So they sent it to number 10 Downing Street.
And Murdoch does care about copyright. Yes. We know that. Yes.
I think was it pre-Murdoch? I can't remember when he bought the Sun.
But anyway. You're ruining the punchline. Yes.
No,
so
you had
anyway,
the Sun then.
And then after that, you know, there was a whole great press furore about me revealing all the nation's secrets, which of course I wasn't doing. And in the end, it was cleared, and I knocked out a few things that I was asked to change, and that was all.
Are your Liz Carlisle novels vetted?
Yes. The rules are that anything I write that can be seen to relate to my work in the service has to be cleared. So I religiously send in my novels every time, and they read them. And okay, I get little notes back saying, please would you not use this pub, you know, the Queen's Arms in Highgate. Please use the King's Head in Camden or something instead. Which obviously means that I've inadvertently fallen over some place that they are currently using in an operation. But as it's a number of years since I knew anything about the details of their operations, I don't think there's much chance that I'm going to reveal anything that will damage the nation's secrets.
But Glenn, your book was heavily redacted.
It was. 40% of my manuscript, 40,000 words of the initial 100,000 words were taken out. The restrictions or the obligations for me are the same as we just heard, and they are legitimate to protect the legal mandate and obligation of the CIA's Publications Review Board is to protect sources and methods, and that's fine. We shouldn't be able to say that so-and-so is spying for the United States, or here's how you pick a lock, or things like that. That's all legitimate. Unfortunately, or not surprisingly, sources and methods, which sounds like a clear guideline, is a term of art, and it can be interpreted in different ways. So, depending on the political winds and the administration in power at a given moment, it will be interpreted more restrictively or more expansively. And clearly, since I was writing about rendition, detention, interrogation, and possibly torture by American officials, this would be of concern and for political administration and a governmental institution. So they were aggressive in trying to stop me from really writing anything too coherent, which I succeeded in doing. But they went well beyond, frankly, sources and methods, and I've told many people before, but it bears repeating. These are literally true examples. I quoted T.S. Eliot, and they censored that. And
that's on taste grounds.
Well, I responded. I told them that, you know, snobbery was a bad thing, and I applauded them for striking a blow against it, but that was not their job. I quoted Rudyard Kipling, and they censored that. At one point, I called a colleague a gibbering fool, and they censored that. I said, I made the dramatic revelation of national security by saying at a certain moment I found that headquarters, my colleagues in the field, and I all disagreed. And they censored that, and I said, I'm not allowed to disagree, and apparently the answer is no.
Oh, we could certainly do that in the court.
You know, so
were there areas where they would think that you were revealing things not unlike WikiLeaks?
No.
Glenn,
it doesn't work.
The man that you were sent to interrogate, you called in the book Captus. What was his name?
I may not say.
Will you deny that he was Pasha Wazir?
I may not say.
That you interrogated him near Rabat?
I may not say.
And that you went with him to a CIA prison called the Salt Pit Prison in Afghanistan?
I went with the detainee, whom I call captives, to a facility I call Hotel California. I may say that, but I may not. I use the word may. Obviously, I can confirm or verify or clarify.
What is the point? What is the point of these denials?
For me?
For you.
Legal liability. For me, it's legal liability.
What liability do you face?
Well, my obligation is not to reveal sources or methods. And if the CIA decides in the formal process of publication review that certain statements or facts are not allowed, then I am enjoined legally from revealing them. So I will not confirm, deny, comment at all on things that I may not do. So there are enterprising journalists, some of whom are competent and principled, who
have come to certain conclusions.
Have come to certain conclusions, and they are welcome to do so. I will defend their right to do that, but I may not comment on that.
On that note, we're going to end. It's 10 o'clock, and it's time for the signing. Will you join me in thanking our panel very much?
And our moderator.
Well done. Well done.
We're getting up.
Thank you very much.